All right, so I listened to a lot in the subcommittee as well as the full committee on this. Now, this discussion about preemption and the Controlled Substances Act, I don't recall this at all, so this is new to me, okay? I just did not pick up the nuances of what's being talked about here, although I think it's an important subject. So what I think I heard you say is that the Controlled Substances Act, and that's a 1970 bill, correct? Something like that?
71, I believe.
What I've written down here is that it anticipates the states doing something differently than the federal government, or that it provides for the states doing something differently than the federal government. I mean, what was the argument you're making?
Okay, so in the Controlled Substances Act itself, okay, 21 U.S. Code Section 903, application of state law, it states as follows: no provision of this subchapter shall be construed as indicating an intent on the part of Congress to occupy the field in which that provision operates, including criminal penalties, to the exclusion of any state law on the same subject matter. Okay, so in regard to the Controlled Substances Act, okay, that's what we're talking about here. It is not the intent of Congress to preempt the field. It expressly declares that it's not preempting the field. It expressly says this cannot be read in such a way so as to interfere to the exclusion of any state law in the same subject matter. And the cases that decide this preemption question, whether it's express or implied, in the area of medical cannabis laws, they have found there is no preemption. And again, I could go through and read you. I've got 7 or 8 highlighted quotes from that court case that but I will just refer you to the case. And again, the case is White Mountain versus Maricopa, 241 Arizona 230. And it's a Court of Appeals case, 2016. And it provides just an excellent, multi-page analysis of why preemption does not exist in the area of the Controlled Substances Act when it comes to a state's medical cannabis laws. And so I say all that because I know that members of this body have concerns about doing things that are contrary to federal law. I mean, they respect the federal law. There's a supremacy clause in the Constitution. So my point here is to say there is no preemption here, which is in large measure why you've seen 36 states take advantage of this. Mississippi, okay? On January 19th, the Mississippi House of Representatives passed a medical marijuana bill that's a lot more liberal than this one, a lot more conditions, allows smoking. I mean, doesn't have all the things I've built into this bill. That House in Mississippi passed it 104 to 14. The state Senate passed it 45 to 5. Mississippi.
The senator from Spartanburg. Senator McCoy, he refused it. Senator McCoy.
Thank you. First, are you familiar with the doctrine of comity? M-O-C-O-M-I-T-Y?
C-O-M-I-T, yes, I am.
All right. And could you explain that to the body?
Well, the doctrine of comity, as I understand it, is between different sovereigns or different levels of legislature and Congress passing laws and South Carolina passing laws. The doctrine of comity encourages them to be read in harmony, is my understanding of it. And that may be an imperfect one, but that's my understanding. And
that's a clean statement of what comity is. So as a matter of public policy, South Carolina can adopt a comity approach to this legislation, or it can be opposed to that. Would you agree with that?
I guess I would answer the question this way. Because the Controlled Substances Act, which is the federal law that we're working with here, as opposed to state laws that are in this space. I mean, so for purposes of comity discussion, those are the 2 different types of laws we're talking about, the Controlled Substances Act and the state laws. I do not think, and courts, cases that have considered it, have not concluded that passing of medical cannabis laws constitutes a lack of comity with what the federal government has done with the CSA, because the CSA on its face expressly says it is not intended to preempt state action in the space of controlled substances, and because in its operation, medical cannabis laws do not make enforcement of the federal law impossible, so that there's no obstacle or implied preemption either. So I guess I would answer it by saying I don't view the adoption of a medical cannabis law to be a violation of the principles of comity. None of the funds made available under 4 of this Act to the Department of Justice may be used with respect to any of the states, and then it lists all the states, and then at the very end it says, to prevent any of them from implementing their own laws that authorize the use, distribution, possession, or cultivation of medical marijuana. I'm reading it verbatim to you.
Okay.
I'm not trying to pull any punches. It is what it is.